Well, good morning, everyone. Thank you so much for joining our webinar this morning. We're about to get started. My name is Kate Souza. I'm the Senior Manager of Events and Strategic Partnerships at the firm, Brown Rudnick. We're very pleased that you're all here to join us for our webinar this morning, Crisis Management Tips, Navigating the Legal Ramifications of the Global Microsoft Outage. I'm going to kick this off to our partner, Dan Healy, who will introduce our esteemed panel of attorneys today.
Thanks very much, Kate. My name is Dan Healy. I'm a partner here at Brown Rudnick, and I co-chair the insurance coverage group. And we represent the policyholder side of things and pursuing coverage. Today, we're going to be presenting on what most of you have already heard about through various news sources, where we had the meltdown, as it was described, on a global basis for users of CrowdStrike and Microsoft software. Very briefly, since we're recording this, we're lawyers, so we all come with a disclaimer, and that is that we're going to express our own opinions today, not the opinions of our clients or our law firm. That said, we're excited to talk about this topic because it's fresh and new and still happening, and there are a lot of different considerations here that make it different from a lot of other events. One of the areas in which I've spent a lot of time is on cyber insurance recovery, and this is a whole new interesting type of issue that we're going to need to work through with a lot of clients to help them recover. I'm very lucky to be here today with several of my colleagues who are very deep on computer and technology issues and the legal problems and solutions that they can bring for those problems. Ian DiBernardo is up in our New York office, and he is one of the chairs of our intellectual property groups, and I found out this morning he's even an electrical engineer. So he'll have a lot that he can share in terms of the technical issues here and the contract provisions that are in play. On my screen, my colleague Matt Richardson is coming up as another Ian DiBernardo, but his name is Matt. You'll be able to recognize when he's speaking because of his distinctive accent, which doesn't sound like the rest of us. I'll leave you to guess where he's from. Matt is a lawyer with a tremendous amount of experience in not only data privacy, but in crisis response, particularly where there are computer hacks and computer breakdowns and computer malfunctions, and clients find themselves needing to immediately respond. And last but certainly not least is Stephen Pally, who I've worked with for many years at multiple law firms. Stephen is very capable and in fact wears multiple hats. He's a cryptocurrency lawyer. He's an insurance recovery lawyer. He is a part-time software designer and can bring a lot of insight into these types of problems that present multiple heads of loss and types of issues that clients will need to overcome. And he co-chairs our digital asset practice here at Brown Rudnick. So as you can see, we've got a great panel put together here, all award-winning lawyers who can present very concise and effective insights in how to deal with this problem.
Hey, Dan.
Yep.
I wondered, thanks for the lovely introduction. There's one thing I thought might be useful to say as an introduction. We're definitely going to talk about CrowdStrike and what happened. And I think what's more interesting to me is not who's going to sue or get sued here, but what can we learn from this incident about the future and about how to mitigate or prevent losses? What can we see that's interesting? And to me, what's interesting is computers are still very new. The internet is still very new. We've got incredibly complicated systems, software that is built from hundreds, sometimes thousands of packages created by different people. You've got complicated counterparty relationships. So we're literally making the law and making the risk management framework for this sort of risk on a going forward basis. So that's when I look at this or I interrogate an issue like this, I think, what can we learn about this and how can that help us mitigate against future similar losses, even if they're not on as grand a scale?
Yeah, no, that's great. And as one of the things we'd like to do here today also is run this as a bit of a discussion. So we encourage you to ask questions. You can put questions right into the chat, and we're happy to take things on the fly. And we think that'll be interesting for the audience as well, to see what issues other people are facing and what obstacles they're trying to overcome. With that, I'll happily pass the baton to Matt Richardson with some of these early data points to talk through what happened and where we are.
Thanks, Dan. Well, yeah, it's worth noting that we still don't know exactly what happened here. We've just seen the preliminary incident report, which is the sort of the immediate after action report to show what CrowdStrike think happened, and it isn't good for anybody. So CrowdStrike is a company that is sort of like an antivirus software company, but they do security at a live level. So they monitor networks, and they have a cloud-based system that prevents cyber attacks at a macro level, and then at the user level. And it is used by mission critical businesses, so airports, hospitals, that kind of thing, to ensure that their systems are not compromised. And to be fair to CrowdStrike, they're pretty effective. They work pretty well when they work. But what happened last week, and I must disclaim this by saying that I was caught in this kerfuffle as I was stuck in Chicago airport for 11 hours, is that CrowdStrike pushed out an update which was faulty, and it caused a sort of a looping crash to occur on all of these mission critical computers, including Chicago airport. And as the woman at the counter at ORD told me, well, you see, the baggage handling system is run by a Microsoft computer, so you're probably not going to get your bags on the airplane. But that's not as much of a problem as the weight and balance system, which is also run by Microsoft. So if your bags do get on the airplane, the pilot can't take off. But that's not as much of a problem as the fact that the pilot credentialing system is run by a Microsoft system, so we're not going to get you a pilot either. And therein lies the problem, is that these safety critical systems, mission critical systems, are so reliant on these fairly serious single points of failure that when one fails, the whole thing is done. And that's what took place 10 days ago. And everybody is still trying to figure out who is to blame, how it came to be, and as lawyers, we're trying to figure out who you can sue.
Yeah, no, and it's very interesting just to chime in. I thought, we have, 70% of Fortune 500 companies, but Microsoft, it was estimating that only 8.5 million Windows devices were affected, which in the grand scheme of Windows devices out there in the world is a very small number. And similarly, CrowdStrike reports that it has about 29,000 plus customers, which, while a big number of people to potentially have very angry at you, it's not actually a huge number in the realm of computer users. Nonetheless, to Matt's point, we had these systemic failures in major industries. So
I mean, you think about that number, 29,000 customers, which in the scheme of things isn't serious, but it turns out it's basically every airport in the world, and like most of the hospitals in the country. All of these really like security essential systems where you don't want to get hacked under any circumstances. You employ CrowdStrike to stop that from happening. And unfortunately, on this occasion, CrowdStrike was the one that caused the issue.
Hey, let me ask you from a software standpoint, Matthew. I guess at this point, we don't know whether or not they were quote unquote testing this in production. In other words, did they push this patch live without running it on testing or staging servers? If they did push the code, if they were basically testing in prod and they did push the code live without any sort of adequate testing, who would be responsible for that, absent any contractual provisions?
Well, if they did do that, and again, we don't know what happened. And we do know that CrowdStrike responds very quickly to developing threats. And so potentially they have some excuse for this kind of behavior. But if they pushed an update without properly testing it, that's just plain negligence. And it would be CrowdStrike on the end of the receiving end of that problem.
Yeah, certainly it would be a claim under negligence, but your point earlier about lessons learned, right? Putting on my hat as co-head of our U.S. technology practice, where we negotiate a lot of these software and related service agreements, right? Who necessarily wants to rely on that? Today, everyone's typically focused on cyber concerns, but as Matt explained, right, that there was no malware here. It was simply an error. And so it's a good reminder to focus on those contractual provisions that center on the maintenance updates and the upgrades to the software, and to have explicit provisions around actually non-production testing, what happens before they actually push out these updates. Great point, Stephen.
Well, I have another question related to that too, which is software is incredibly complicated. You see it on your screen and it looks simple, but you've got software that has been compiled that before then was written using some sort of high-level programming language. It's probably comprised of, for complicated software, hundreds of libraries that were written by other people. It's interacting with dozens or hundreds of different operating systems on different types of machinery. I guess the question is, maybe this is a contract question, but how do you, let's say you're pushing back on that contract requirement that addresses testing before pushing something live. Is it possible to establish the bounds of your liability? Because I question whether or not, maybe this is a software engineering question as much as a lawyer question, but can you test for every exigency? Part of what you're also testing for is software working on operating systems and hardware that under conditions that you may not be aware of yet for a system that someone buys a year from now. So how do you negotiate that? And what are sort of the reasonable realms of obligation that someone should or shouldn't take on? Or maybe a better question is, how do you answer a client's question about that? How do you guide someone to negotiate those provisions?
Well, there's a wider point actually, which is, first of all, we don't even know who had a contract with CrowdStrike, right? Oftentimes there's an intermediary in between that is like a service agent that deals with these large enterprise systems, and CrowdStrike just move into that, are just a sub-vendor of that contract, right? And so likely there's some limit of liability in there, of course, because that's how most contracts of this type would work. But again, is there a limit of liability when, for example, there is some personal injury or death caused by it? And there's a question from Paul Feldman at FTI who's asked about the other plaintiffs. Now, we've talked about the airports. Sure, that's just business loss, right? But what about hospitals? It's not impossible to conceive of a situation where a fatality could have resulted as a result of this, because an ambulance wasn't dispatched properly, or a pharmacist wasn't able to distribute medicine as they were required to. Now, as luck would have it, so far, we don't know any of those types of serious problems, right? Of course, we were all inconvenienced, but it's not so bad as say, a person dying. Now, you can't possibly exclude liability for those things. In fact, I don't think there's any state that allows you to exclude liability for personal injury or death. And no amount of contracting is going to get you out of that. Now, you can try and limit your liability for certain. There'll be arbitration provisions in the end user license agreement. There'll be no class action. There'll be a class action waiver, but that doesn't help the people who are stuck in the airports, who are going to go, well, you know what? Whose fault is this? I lost 11 hours of business. That's what, at my billable hours, that's thousands of dollars. And I'm just one of hundreds of thousands of people who are stuck in those airports. That's millions, maybe billions of dollars wasted. And you can't hold up that tide back forever. So, I mean, even contracting is going to keep you in a bit of a, or is going to put you in a position where maybe it's better, but you still have liability to parties who aren't party to that contract.
Further to your point, Stephen, right? We spend a lot of time, even before the contract is signed, right, thinking about use cases, client use cases, and these issues of interoperability between systems and software, and really try to reflect that in the documentation. Right? A lot of times, a provider may give a rep that the software, the service is going to operate as intended, as reflected in the documentation, but a lot of times clients, are quick to move on past that documentation. It's really a good reminder to focus on that and really understand the bounds of what that typical rep is that you're getting.
And Ian, I think it might be useful to talk about also, there's a difference between having sort of that service agreement in place where you have an ongoing service obligation and a software license, which could be part of an agreement or could be a standalone, this is how I'm acquiring the software that I'm using, and the different sets of obligations that can go along with those, which, as I understand it, can be quite different in terms of, who's responsible for things that happen.
Absolutely. There's the access to the software, and then there's the services around maintaining it, updating it, and providing the support for issues like interoperability. And it's not uncommon for us to, seek different levels of protection on those two sides, different levels of indemnification, different types of reps and warranties, and for that reason, those two aspects of a deal transaction are often broken out and treated separately. It gets you an opportunity to be a little more granular in the protections that you seek.
Right. And to Matt's point then, so, do you have instances where when you've got, the party that is sort of stuck in the middle who has this service agreement with a software provider is unable to provide its own services to its clients, and those are the claimants in our scenario, where that service agreement may provide the type of protection to that party in the middle, whether it's an airline or a hotel or a hospital, against those third-party claimants who are its own customers and consumers.
It often falls on the extent of indemnification from the provider right here, CrowdStrike. And so, as Matt mentioned, right, you certainly have carve-outs on limitations of liability and coverage for negligence, but you certainly don't want to have to rely on proving that. It's nice to have explicit clauses on what exactly they do or should be doing. Right. Again, in the cyber context, you usually have typical reps and obligations around what level of technological, administrative, and physical controls are in place around the system. But yeah, all too often, issues like these may not be explicitly covered, and they should be. Right, pushing out updates and upgrades, whether or not there is testing.
Right, and that's will be one of the issues I think that we'll see develop here, is that obviously this is not something people were expecting. It's not something that is likely that anyone at CrowdStrike or Microsoft was intending to happen, but nonetheless was a very significant, as we said before, global issue. And so working through how that fits into a contract where maybe this wasn't something contemplated could really present some issues and turn on exactly what the contracts say. And in this situation, as I understand it, and we're going to need to see more facts develop in terms of which affected companies, businesses out there are seeking recoveries, is that CrowdStrike actually has a lot of its agreements directly with those businesses. In some situations, you have software layer upon software layer, and you might have CrowdStrike having an agreement with Microsoft, who in turn has an agreement with the customers. But here, as I understand it, there are a lot of direct agreements between CrowdStrike and these very large businesses, and that presents a different set of issues as well, because you have sort of, in a very practical sense, there's sort of the contingent ability to operate, as we've all learned, where the software has to work together. But you have separate contractual agreements with CrowdStrike, Microsoft, and maybe other operational software that you have on your system that was affected by this. And so, that presents just yet another layer of how you may have a different set of terms and conditions with CrowdStrike and a different set of representations and warranties, and then different indemnity than you do with Microsoft, particularly where Microsoft is widely reputed as being extremely difficult to negotiate with in terms of changing the form agreements that they come in with.
Yeah, and that really goes back to the notion of use cases. When you're negotiating with a provider like CrowdStrike, right? You want it clear what exactly are they supporting? Current version of Microsoft's operating system, the last 2 versions, right? You need to have that flexibility as a user, get that level of support.
Yeah, and one of the things we talk about a lot with clients too is, to go back to one of Paul Feldman's questions here in the question list is, the different types of businesses beyond just the airlines that were affected, and 2 of them that he has listed there that have been in the news as well are hospitals and banks. And when you think about it, while these agreements often are talked about in a vacuum of thinking about the software, one of the things these businesses need to be thinking about, and that this incident may have highlighted, is that different types of users have an entirely different set of risks. There are considerations for a hospital that are entirely different from a consideration for a bank in terms of what really could happen if they're unable to function. And nowadays, any large business, it can be crippled by the lack of access to operating platforms for software, but the risks from an inability to have certain functionality can vary greatly. One of the things also here in Paul's questions are, is Delta the only one that took a long time to recover? I had family members flying on Delta that week, and I do know that it took longer for them than some of the other airlines. We had to find other tickets on other airplanes. But I think we still don't know really. I mean, for hospitals, even in the regular course, if you have a surgery canceled, it doesn't mean it just gets moved to the next day. That's not how it works. And depending on what surgeries were being canceled and for what types of patients, there are a lot of risks there that could get into things like bodily injury, which is not something that a lot of people think about when they think about their software, but are real risks here. And that could take weeks, if not longer, to rectify, at least from the hospital and patient point of view.
Well, there's an interesting distinction too between the airline passengers and the patients. The airline passengers are the airlines basically have a limitation of liability that is to a certain extent statutory or by treaty. There's only so much they can claim. The airlines are also protected by something called the economic loss doctrine, which prevents claim for damages from breach of contract for purely economic losses. So I question whether or not you'll have significant damages there, absent some way to work around that limitation of liability. I can't remember the terms of carriage. It's what's interesting though, and really problematic is, you have a patient on the table and they die because of, software goes out. That third party claim that Matthew articulated is much more real there. Because to Matthew's point, you can't in a contract, generally speaking, invalidate claims by third-party claimants, but you can try and mitigate that with indemnity. But I think that's where some of the probably thornier risk or loss comes out, and we may see some of that too. The same thing and this goes to something in insurance they're going to be talking about, Dan, sort of contingent business interruption, third-party losses. So losses to people who didn't receive something, for example, as a consequence of this, or didn't receive power as a consequence of something like this, and were out. So someone not in direct privity with CrowdStrike, but who suffered a loss to their business interruption, notwithstanding that.
Right. And I will turn to insurance in a little bit. There's one other thing though that came up in the questions asked that I want to address, and that I think is hint at the idea of, well, don't all these businesses have a duty to mitigate their damages? The answer, of course, is yes. But that doesn't mean that just because an airline or a hospital or a hotel or a bank may have had a more extended lack of functionality or failure to be able to return to normal operations means that they didn't mitigate. It may mean that they had the software in use in a different way, and recovery was more different. They will need to be prepared, and everybody should be thinking about this. If you were affected by this incident, or your clients were affected by this incident, you should be thinking about, well, what was done to mitigate it? If they just threw their hands up in the air and said, well, too bad, we'll just sue everybody later, which is unlikely. I doubt very many people did that. That's not a great way to document your loss. Whether you're pursuing a counterparty under contract terms, or you're pursuing an insurance company for recovery, it's also just not a good business practice most of the time. So I'm sure that a lot of these businesses were taking all kinds of action, not only over the day that this was happening, and that there was a complete loss of their Microsoft operational platform, but even after the fact, they were, and that mitigation probably cost time and money, and they incurred additional expenses they would not normally be incurring. All of those things are something to consider, and it's not just the straight we weren't able to sell this or conduct certain business with people during, or our customers during that time period, but what else did we have to do in order to get back to full operations? And then the last part is, you can recover business interruption, contingent business interruption. You can recover indemnity costs from a counterparty for the time period where you are partially operational. I'm often surprised a lot of clients don't understand or haven't thought through. Perhaps thankfully they haven't had something horrible happen before, and now they have a problem for the first time, but they haven't thought through the idea that, yeah, I'm back up to 60%, but I'm only at 60%. And that's a loss. That's a 40% loss of what you should be doing. And that's something that if you can figure out how to demonstrate it, then you may have a very good chance at recovering that amount from someone who's responsible for your inability to return back to full operation. So it may well
like
be
insurance might be a good way to address some of this, Dan.
Yeah. So is it time to switch to insurance? All right.
Yeah, and you should you mentioned, we both talked about business interruption and contingent business interruption. Maybe just, I know we have some insurance folks on here, but for folks who don't who know the difference, maybe you can clarify that to start.
Sure. Yeah, it's something that comes up all the time in these situations where you have businesses down, where people are not able to use whatever it is they need to use that's part of their business to make money. And so business interruption is a component of coverage, and it's to Stephen's point about computers being new and the internet being new. Business interruption is not new. It's part of property policies going back hundreds of years. So often the wording in your business interruption coverage is not as up to date as your computer system, even if it's in your cyber policy. But you can also find business interruption in your cyber policy. The idea behind it is that if part of your business suffers harm and you're not able to operate, or you're not able to operate at full capacity due to this harm, and that harm is covered, the business interruption coverage pays for your lost profits, to put it in as simple a sentence as possible. There's more to it than that, and you need to be able to establish your lack of capacity or your inability to operate. Contingent business interruption is the next step over. It's where perhaps you have a supplier who was supposed to be supplying you with a service. It doesn't have to be goods, and you're not getting that service. And because you're not getting that service, you can't provide the service you're supposed to be providing to your customers. You can see instantly how that might apply here. If you have coverage under your policy for that type of contingent business interruption, and the supplier of that service suffered something that would be covered under the policy, then you may well have coverage. It's those provisions are different from one policy to the next. So just because you talk to somebody who said, "Oh, I looked at my policy, it doesn't apply," don't assume you don't have the coverage in your policy. Also, because it's under both property policies and cyber policies, that is something to consider here. There are a lot of property coverage policies out there that have special extensions for cyber types of events, and they cover property that includes things like data and computer apparatus. There are cases out there right now that are going in both directions and that are currently litigating whether software is included in that coverage extension. It's gone different ways in different states to date. Without getting into sort of a theoretical, metaphysical description of it, some courts sort of treat software as if it's physically nothing, and other courts say, no, if data is something, then software is something, because it's all, without getting too technical, I'll have Ian correcting me here. There's, whether you want to call it electrons or whatever you call it, it is something that is there. And if your policy provides protection for it, even if it's electronic, then the distinction between data and software is not a real distinction. As you can probably guess, that's the way I go, including because for most people that means there's coverage. Under cyber policies, obviously they're designed to apply to computer loss, data loss, all of those types of things. The thing to be aware of here, as Matt mentioned at the outset, this was not a computer hack. This wasn't, a malware program that was launched. And those are things we've seen before, including on a global basis. But I think that there's going to be a lot of discussion about how what did happen, which we don't know all the details about just yet, fits into the types of coverage in a lot of cyber policies, especially where you have a piece of software, which is what malware is, that was pushed out by a third party, which has an analogy to a threat actor pushing out malware that gets launched in your system, and renders your system unusable. I mean, essentially, if you think about a typical ransomware event, that's what ransomware does. It's what it accomplishes. It shuts your system down until you do what the threat actor wants you to do. So while I'm not in any way insinuating that CrowdStrike was trying to shut down anyone's system, that's what CrowdStrike accomplished. And it accomplished it by pushing out a piece of software that had code in it that shut down the computer. We've seen a lot of people throw around words so far talking about errors and logic flaws, all of which still remain to be seen how it goes. But I think it's important that even if it's not necessarily what a policyholder or an insurance company might have said typically is covered, this isn't a typical incident, and you shouldn't write off your cyber coverage just yet. I think you need to take a look.
What about, so it's interesting, we've been focusing on claims that people might have about CrowdStrike. CrowdStrike probably has software too, right? So what are the sorts of policies that might apply to claims that either contractual counterparties or third parties might make against CrowdStrike, and who might it be able to claim against?
Right. We started out with business interruption, which is what we call first party coverage. But to jump back to what Ian and Matt were talking about, where you have your counterparty and you have liability, which is third party coverage. And in cyber policies, you have both third party coverage and your first party coverage. And then in E&O policies, you have a lot of liability coverage. Some of them are tech E&O policies and specifically cover computer issues. So those are things to think about. And those, in a perfect world, will have been contemplated when someone, hopefully as smart as Ian, was working on the client's contracts and figuring out how to align the indemnity obligations the limitations on liability, and the insurance provisions, so that an insurance policy would be there to respond. That's what everyone wants to have happen. Unfortunately, due to all sorts of things, it doesn't always align perfectly. But that is something that people need to work through, because there may well be claims based on the services that were supposed to be provided that were not provided. There may be any number of different types of claims that can be brought depending on who we look at. If it's a customer, if it's another business that if we have, just to slow down for a second, if we have a business that was affected and was shut down by this incident, and they were supposed to be providing services to yet another business and couldn't, there may be liability there based on their own services contract, which may have insurance tied to it. Perhaps they have E&O coverage that is designed to respond when they fail to provide services that their business partner will claim as their fault. And then from that business that got shut down, they may also have claims as well, based on the fact that they were unable to operate. And so we have this sort of multi-layered set of contracts that will have different provisions and may have different insurance policies that are supposed to be responding. Hopefully they do have the provisions in there for the indemnity. Hopefully they can make the claims. And of course, from my vantage point, hopefully the insurance companies will be responding appropriately and paying these losses.
And it seems like there's sort of a functional and categorical damages issue here too. We focus mostly, and I think the media is focused mostly on financial losses or inconvenience. But I mean, I haven't practiced I haven't done products liability work for years, but I started out doing that. My mind goes to things that are catastrophic. I guess that's also part of being a lawyer too. You always think of the worst case, but let's say, a building has a fire suppression system that is connected to software, right? You've got very fancy building information system, and the fire suppression system shuts down and the building burns down and people die. I think sort of conceptually that's easier from an insurance standpoint, right?
Yeah, I mean, fire is one of the easiest examples, right? Because it's definitely covered and it shouldn't happen. And if it destroys the property, it's covered. And if you can trace that back to a software issue, that I would argue is still covered.
It's also worth noting that we don't know yet what happened, right? We don't know whether CrowdStrike was negligent, whether it was just some mistake, or whether they were grossly negligent. And in the case of gross negligence in most states, you cannot exclude liability for gross negligence. And so whilst they may think they have a liability shield, if some clever plaintiff's lawyer, and there are plenty of them around, decides they want to bring a case in gross negligence, that liability shield isn't going to protect them. And until we get some more granularity on what actually did happen, there's a potential that this could be, as Pally says, some type of products liability. It could be a plain negligence matter. It could be nothing. It could be a contract matter. But until we get more granularity on it, we don't know. But there are chances for there to be plenty of causes of action brought against CrowdStrike. And if it's a product liability matter, which for some technical reasons it might not be, but if it is, then every entity in that chain of commerce is as liable as any other entity. If it was CrowdStrike to Microsoft to some third-party enterprise software company, they're all as liable as each other. And those things will need to be bottomed out once we have more facts on how it is this catastrophe took place.
Yeah, and it's not clear, to Matthew's point. Products liability law, strict products liability applies to products. The law in the United States, at least to now, is somewhat mixed as to whether or not software is a product or whether it's a service. When we think of products, traditionally, you're thinking of things like, a punch press or a toaster. I think we'll see significant development on the law on this point in the next 10, 20 years. I mean, remember, software is still new. We've had products, we've had machinery for hundreds of years, and our current conception of products liability law, strict liability as a consequence of that, is really a creature of the late 19th and early 20th century, and a different type of industrial capitalism than we have now. So there isn't a clear answer on that from a legal standpoint. However, from a contract drafting standpoint, there's certainly a risk that needs to be accounted for on both
Right.
sides of the contract.
And I'm curious, Ian, so, I mean, we file a lot of trademark applications where we say that what is being sought, the trademark is for software as a service, platform as a service, right? And we're talking about software, and we're talking about it as this is a service, and we can protect it as a good in the market, but it's protected as a service rather than a product. I'm curious whether that's something that gets baked into the contracts that you work on for, the provision of software or services that go with the software.
Yeah, and there's certainly different types of situations, to Stephen's point, right? I mean, sometimes software is baked into a product, right, that's being sold. It's software for operating a widget, a system. And then there's, standalone software as in this situation, right, where it's really not tied to a tangible item. And there it's really a question of focusing on the individual contractual provisions to make sure these types of situations are covered, right? Not relying on kind of the default, law around the sale of goods, right? The better course is really to kind of assume it's going to be treated like a service and make sure you have the protections baked into the contract.
As opposed to a good. I should have said good, not product. That's the relevant distinction, good or service.
Yeah. I guess to add to your comments, Dan, we certainly see insurance taking a larger role in our contract negotiations, right? Asking that the provider have insurance coverage, and like your view on it, especially in the technology space. Things are moving quickly. Established clients and users are often looking to startups providing new types of software and services. And so from my perspective, right, getting that insurance coverage from kind of the earlier stage software provider is important. Or, you don't always get the transparency in what type of coverage they have, but there was a time where it was kind of a check the box type provision, but I think now we're seeing a lot more focus on what that coverage is, what should they have, what can we expect the provider actually has, and where we can be pushing back.
And you've got to remember that before this happened, I'm not sure anybody really conceived, at least nobody seriously imagined, that something of this scale could occur. And that now anybody operating a large enterprise system will have to ask their insurance provider to cover an eventuality like this, which is some third-party mistake as opposed to malware. I mean, everybody's covered for malware proper, sure, but this was not contemplated by most insurance purchasers, and now it will be.
Well, the nice thing about things not being contemplated by insurance, it means that an insurance company isn't necessarily going to explicitly exclude it. Insurance companies are really good at doing that too. I knew that breaches would become an issue when, as early as 2001 and 2004, you saw insurance companies who issued standard commercial general liability policies redefine the meaning of data and start excluding breaches. This was before there was a terrific amount of litigation. So we'll know as soon as we see an ISO exclusion for third-party software error, testing in production. We'll know that it's a thing long before it's actually a thing at scale.
Yeah, it's very interesting because one of the things we've seen in the industry lately in the past few years is many more questions about what data security and software is in use to protect a system. You have these companies that had CrowdStrike for that specific purpose, and then that ends up being the source of a major issue and a shutdown. It'll be interesting to see how the insurance company does react to it.
Right. It might have even been a requirement by many underwriters. So the thing that you used as your safety system, actually, if that actually creates a problem, You know, it's, you never know with insurance companies, but I sure would have a hard time accepting that the thing that you required me to do is not a thing that you provide me coverage from when there's a loss that results from it.
Right. And I mean, after all, insurance is for that unexpected loss, right? That's when it's supposed to kick in. That's the point. So in that regard, where you have a lot of the contract provisions that was everything everybody could think of, and somehow this doesn't fit nicely, in many instances, that's where the insurance can kick in. So even if it doesn't perfectly align, sometimes there's a benefit to that. And that's something to remember. And because I need to say this in almost every presentation I ever give, you know, you should tell your clients, or if you're someone who is affected or an affected business, give notice to your insurance companies. Let them deny it. That's okay. This is not something that their claims people have probably thought about or handled before. They're going to need to think it through too. Don't sell yourself short and reach a conclusion that there's no coverage. At least submit notice, and if it can help at all, that's great. If you don't give notice, you're sort of talking yourself out of your own insurance coverage.
Yeah, and sort of, I guess not necessarily related to that, but I often include this in presentations too. Going back to something Dan just said, when I've had clients say to me, well, why would they cover that? That was just negligent. And you know, my point is, insurance is often insurance against stupidity. It's supposed to cover mistakes. It's supposed to cover things that you didn't expect. It's supposed to cover a plumber who didn't tighten a valve correctly. So this is exactly the sort of unexpected and unintended, which is a phrase that insurance companies will throw at you when you're trying to get coverage. Often it's the exact sort of thing that insurance is supposed to get. The fact that there is no exclusion for it, the fact that it might have been born of stupidity or somebody's negligence, is actually a good argument for there to be insurance coverage for the loss. That's like a threshold issue for insurance and for insurance lawyers.
Yeah, the last thing I would add, just we talked about it, but we didn't really flesh it out too much. But this being a global incident, it is not just U.S. law, and it's not just U.S. businesses. The first reports of businesses being affected came out of Australia because of the time zones here. But that is also something that's important. There might be different types of liability that the same company, or at least arms of the same company or affiliates, will experience in different countries because different laws apply. They may also have different insurance policies and contracts in place there, but not always. And I've certainly worked with companies that have contracts that span at least multiple jurisdictions, if not necessarily global, and similar insurance policies that cover multiple jurisdictions as well. So that will present perhaps a different set of legal risks and questions that businesses will need to work through. And it's something you should keep in mind. You know, it's not just going to be about U.S. law, even though that is a huge driver.
But the question of providing notice is a threshold basic issue. There's something else that people can do at the outset to it, which is if you know you've been affected by a loss and you think there might be insurance. I mean, if you have insurance policies, you should always check. The other thing to do is to capture the cost, set up a separate accounting code and start tracking where the losses are. What are you spending money on to mitigate the loss? Where is your loss of revenue coming from? Because one of the big expenses when you're putting together a claim 3, 6, 9 months down the line is demonstrating that you suffered some sort of financial injury or loss. And the earlier you get on that, the better. And look, even if you don't use it to get insurance coverage, it may be useful from a tax standpoint or tax perspective too. It's much easier to capture that loss if you've got a system in place to do that. And if you have a specific accounting code that you are tracking costs and losses with, and I would say be expansive too. You can always trim that down later, but it can be much more disruptive to try and capture those costs retrospectively after the fact.
And that certainly applies to litigation in general, not just insurance claims.
100%.
Yeah,
And
no,
we'd always rather have that tracked contemporaneously than done in an archaeological fashion later.
it's great. We're building a little to-do list. I was going to go around and say, what's everybody's to-do thing? So this is good. I don't have to put everybody on the spot solo. But if anyone has something else to add to it, we've got, check your contracts, check your policies, give notice, start tracking your losses if you haven't already. What is there anything else we should add?
Well,
to that?
actually getting to notice too, and this applies both to insurance policies and contracts. A lot of insurance policies have notice, have time triggers in them. It may be 48 hours, it may be 72 hours to give notice. It may be as soon as reasonably practicable. First party insurance policies, that is property insurance policies, often have contractual limitations periods in them that are shorter than what might be provided for by statute. Contracts often have notice provisions too, where you have to give notice in a specific period of time. For particular types of insurance policies, if you don't, depending on whether something is a claims made or an occurrence policy, depending on the jurisdiction where you are, failure to give notice as required and to the right person. Sometimes people want to give notice to their broker and have the broker provide it to the insurance carrier. That can be okay. We generally prefer that it's generally better if a client provides the notice themselves. If you get a lawyer involved right away, as opposed to acting behind the scenes, you can suggest conflict where there isn't necessarily one.
Contentious.
It gets everyone contentious, but time. So the things we always check right away are when do you have to give notice by? Who do you have to give it to? And when must a claim be made? Those are like immediately, those are the things you should check for in your insurance policies. Notice, by the way, it doesn't have to be a 10-page letter. I would say usually at the outset, it's better that it be Hemingway rather than Faulkner, which is to say, we just provide what you know. And the reason for that is time is of the essence, but also if you lay out a narrative about what happened before you know all of the facts and before you know the legal context, both contractually and insurance-wise, you may create a narrative that you don't want, that conflicts with what the actual reality is, or where the preferable pots of money are. So notice in my mind, and Dan, counter this if there are exceptions, notice in my mind should be utilitarian, just what's necessary.
Right. You're fulfilling what is usually a condition in the policy. You want to make sure you've done it. You can like with adding up, all of the damages, you need to work through the process and build it. The day one of a loss, the reality is you don't know all of the details. Don't try to fake it, and don't use buzzwords because your colleague said, "Oh, this was a blank kind of event." Just say, "Look, we know we had an event. Here's what we know so far." This is notice of our claim for coverage. And
the insurance company may pay for an investigation too. I think that's also a lot of policies will have a breach response policy. I know this isn't breach exactly, but standard property policies typically have something called sue and labor coverage, which is language from old marine policies that you still see in many property policies. And the idea is they will pay for you to mitigate your losses. You have to let them know that you're doing it. Even if you don't have a traditional sue and labor cost, there's case law in many states that says basically, take for example, a wall that's falling over and it's going to hurt someone. If you do that without providing immediate notice to the insurance company, of course, you should let them know, and it saves someone. Most courts, or the better authority, is that you save the insurance company money too. So you should be covered from that loss. But of course, that's also a cost that you should track. So if you need to take emergency measures to protect against, losses, that's something that may be covered as well. I'm not saying do that instead of providing notice, but I'm also not saying wait until you hear back if you need to do things immediately.
Yeah. And the interesting thing there is we had a great case from involving Southwest Airlines at the end of last year. And they were able to get coverage for those types of things where they were giving customers rapid rewards points in compensation for not being able to get out of the airport or having their flight canceled. They were comping hotel rooms. All of those costs ended up being covered in their cyber policy. So think creatively when you are compiling what this really cost your business. So
I'd just add, your comments around notice on the insurance policy, again, applies equally in the litigation and breach of contract scenario, right? That don't provide a narrative that may change, right? Less can be more, and consistency counts. Yeah, should be objective.
What Mark Twain once said is, the great thing about telling the truth is you never have to change your story. Sometimes the truth is you just don't know, and it's not reasonable to expect you to know.
Yeah. All right. Well, we're down to just a couple of minutes left. I don't know if anyone has any other questions they'd like to ask. We're happy to try to answer them on the fly. But if you don't have one right now, don't hesitate to reach out to any of us with a follow-up question. Like most law firms, our contact information is all over our website. We're relatively easy to find and happy to hear from you. So with that, I would say, unless anyone else has any final words, thanks for attending. All right. Well,
Thanks, all.
we appreciate it. Thank you. And we hope your business is actually back to full speed again. But if not, feel free to reach out.